First, we'll hear from Judge Dolly G. Judge G has served as the United States District Judge for the Central District of California since 2010. She currently presides over the Conviction and Sentences Alternatives Program. Everything in the federal government has an acronym. This one is Casa. Before taking the bench, Judge G was in private practice in Los Angeles. Judge Bruce Hendricks is the United States District Judge for the District of South Carolina. Before that, she served as a United States Magistrate Judge in the District of South Carolina. Judge Hendricks presided over the Bridge program, the first drug court program in the District of South Carolina. And finally, we'll hear from Judge Leo Sorokin. Judge Sorokin is a United States District Judge for the District of Massachusetts and previously served as a magistrate judge from 2005 to 2014 and presided over the Court-Assisted Recovery Effort, CARE, Court for the District of Massachusetts. He was instrumental in the development of the Repair, Invest, Succeed, and Emerge program, the RISE program, the district's pretrial alternative court that is currently in its second year of a 3-year pilot. Judge G.
Good morning, members of the Commission. It is my privilege to be here on behalf of the more than 20 very dedicated men and women of the Central District of California who helped to make the Casa program work. I'm not going to repeat the things that have already been submitted to you in writing, other than to say that the Casa program is different from many other so-called reentry or diversion programs in that it is a front-end, no-entry program. And as its name suggests, it is a true conviction and sentencing alternative for a wide range of criminal defendants and criminal offenses. And it has the types of carrots and sticks that make this type of program work. The very potent carrot, of course, is the prospect of no prison time or no felony conviction. And just as importantly, the opportunity to change the trajectory in one's life. And the equally powerful sword of Damocles that dangles over every Casa participant's head is the prospect of failure and incarceration. Today, I'd like you to hear from some of our successful Casa graduates in their own words. But before we do that, I would like to respectfully make a suggestion as to how the sentencing guidelines can become more relevant to programs like Casa during your next amendment cycle. Even a mere acknowledgement by the Commission that programs like Casa exist would help to institutionalize what has already become a new reality in our district, as well as many other districts that have chosen to follow a similar path. Currently, the only places in which the sentencing guidelines have a role in a Casa participant's sentence is in the calculation inserted in the initial plea agreement that is entered into between the parties, and at the time of an unsuccessful termination from the Casa program. At that time, the defendant is returned to the traditional sentencing regime and is subject to whatever penalties that the sentencing judge may deem appropriate, which includes potentially a sentence within the sentencing guidelines. For a successful Track 2 Casa graduate, however, the probationary sentence that Casa judges impose, pursuant to the parties' binding plea agreement, is recorded in the Statement of Reasons, invariably, as a variance. In my view, the guidelines should include language that recognizes programs like ours at the front end. For example, a logical place where the guidelines could recognize such programs is at Section 5B1.1, where a statement could be inserted that in addition to those offenses falling within zones A and B, which may be appropriate for a probationary sentence, that a probationary sentence could also be imposed pursuant to a court-authorized diversion program that provides intensive supervision. Such a small change to the guidelines would signal a seismic shift in our criminal justice system's attitude towards diversion programs. It would recognize the success of these programs and embrace rather than treat them as outliers in the system. This, in turn, could encourage more widespread adoption of such programs across the country. At this time, I would like to conclude my remarks by introducing you to some of our successful Casa graduates, who really are the reason why we do all of this. I wish I could have brought them here in person to meet you, but because I could not, I must simply read a few excerpts of some of the letters that they have written to me and spoken in their Casa graduation speeches. The first that I would like to introduce to you is Mikhail Badalian, who is a Casa graduate from 2014. He pled guilty to bank fraud. He had a criminal history category of 1, and after he successfully graduated from Casa, his felony conviction was dismissed, and he was ordered to pay restitution. This is what he said at his graduation in part. When a firefighter runs into a burning building, it's nothing short of heroic. When a police officer runs into the line of fire, it's nothing short of heroic. Likewise, when a group of people realize that our criminal justice system is failing and our prison system is failing, and they come together to develop a program to try to put people back on the right track and save their lives, it is nothing short of heroic. Ladies and gentlemen, the Casa program is not just a conviction and sentencing alternative. It's a second chance at life, and for that, we are all forever indebted to the program. Especially myself. I know that my dreams of one day becoming an attorney would likely not have been possible if it had not been for the Casa program, and for that, I am forever grateful. But it's not only our lives that the Casa program has touched and will touch. It's like a ripple in the water, and the effects of the Casa program will be felt throughout time. Every client that I'll ever help and every client that will ever thank me will in turn be thanking the Casa program, because without it, none of that would have been possible. In 2016, Mr. Badalian became a licensed attorney, and he will be speaking at the Ninth Circuit Judicial Conference in San Francisco this summer about reentry programs and mass incarceration.
Judge, let me just interrupt you. I know you have other things that you wanted, other stories, but I wanted to get to some testimony here that I'm particularly interested in. First of all, in this program, because we have a similar program in the Northern District, not identical, but somewhat similar. Do you have the consent of the United States Attorney in the designation of any of these people to participate in the Casa program? Is that a requirement, or is it a practice?
Oh, it is absolutely essential. The entire Casa program concept is based around a team approach. And the team consists of a representative from the United States Attorney's Office, from the Federal Public Defender's Office, from pretrial services, from the court. And the people who participate in Casa are vetted by the team. And of course, no participant can actually come to the Casa program unless the U.S. Attorney's Office has approved that person's participation.
So then I would assume that if an individual is subject to a mandatory minimum, that person would not be considered for eligibility in the Casa program, is that?
Well, theoretically, someone who is subject to a mandatory minimum could actually become eligible for the Casa program if the U.S. Attorney's Office chooses to charge that person differently. And so there are many people who are higher level participants, for example, in a drug trafficking operation who are subject to mandatory minimums who would probably never be considered eligible for Casa.
But those people, for example, in a conspiracy, and their role was one of a courier, where legally they may be responsible for amounts that might dictate or implicate the mandatory minimum, Would they be considered?
They could be considered again if the U.S. Attorney's Office is willing to charge them differently, and sometimes that happens. They will have a superseding indictment that will include a lesser charge than what they were originally charged with, and therefore not be subject to a mandatory minimum.
Question.
Thank you.
How are all these programs different than diversion that's available to all the federal courts? Where
I think
don't
that
prosecute or don't handle the case for a year, the person's allowed then to go through treatment, but it's working with the probation office, directly with the probation office that structures the program.
I think that's a very important question because we throw these terms around and we think that we all know what we're talking about, but in fact, there are very different distinctions between a lot of these programs. In the past, a pure diversion program, which incidentally in our district is not favored by the U.S. Attorney's Office, is one where someone is simply diverted out of the system and does not receive a sentence and does not go through any intensive supervision. They simply are allowed to conduct their affairs for a year or so, and if they don't commit another offense, they can then perhaps have their felony dismissed or whatever. The Casa program is an intense supervision program, and it's favored by the U.S. Attorney's Office precisely for that reason. The people after...
I apologize for interrupting, but can't diversion be the same way? Can it be set up the same way? It is in my district.
Yes, it is. We call it a diversion program with intensive supervision, which is distinct from a diversion program that has no supervision. So there are different types of programs in that regard.
Thank you.
So the difference is that in the CASA program, if a person isn't successful in the CASA program, well, first of all, if the person is successful, they may still be convicted. Isn't that correct?
Well, if they are successful and they're in what we call track 2, they are
Right.
convicted and receive a probationary sentence.
So they would, even if they're successful, they may very well,
They would receive
they
no...
would receive a particular type of sentence, but it wouldn't be one without a conviction.
That's correct. It's a binding plea agreement that calls for a probationary sentence in advance.
And if they fail, they then are prosecuted in the
If
normal
they fail,
course
they
of-
would return back to the normal adversarial proceeding where they would be sentenced pursuant to the guidelines or the 3553 factors.
And so in a sense, the advantage is that you don't go through a trial with that person because that person has essentially pled guilty. And as the sentencing has been deferred as distinct from a pure diversionary program, which they never even enter a plea of guilty.
Well, not only that, but they actually go through a year or sometimes 2 of intensive supervision by our team, which includes a whole host of services and exercises that are intended to change that person's attitude and to prevent them from recidivating. And I see my red light is on, so
I'm responsible.
so I will pass the microphone to Judge Hendricks.
Thank you.
Thank you to the commission for having me here today. It's an honor to appear with my colleagues. I want to start by emphasizing that I'm here in a representative capacity. I've been tasked with facilitating our drug court in South Carolina, but I'm representing all the stakeholders there that make our drug court work and function. It's not a Lone Ranger enterprise in South Carolina. And even though we're one of the older federal front-end programs, I represent so many more state and federal programs, and we stand on the shoulder of their efforts. My testimony today is simply an account of our experience and an approximation of our best practices. Running a federal drug court is always one part legal and one part science fair project. It's glue and popsicle sticks. We believe Section 3142 gives federal judges the ability to tailor these kinds of programs. But that doesn't mean that in South Carolina we've figured out all the answers or that all aspects of this work fit cleanly within the existing statutory and guideline schemes that exist. And so today I'm going to do my best to share our experience in drug court in the federal system. And as some of you know, the best way to understand it is really to see it. So I'm going to reciprocate your hospitality to us here today and invite you down to Charleston, South Carolina. Judge Breyer can attest that we take our hospitality very seriously down there. The Criminal Law Committee has come to visit. I'm just saying, it'd be an interesting experience, and we'd welcome you to come. Let me just say a couple of quick things, and then I'll answer any questions you might have. South Carolina sought to create an alternative program to meet a need. That need was that the district judges in our district felt that we had inadequate tools at our disposal when sentencing a particular category of cases. And at this point, over-incarceration is an indisputable problem in the United States. Front-end, pretrial drug courts are just one way of addressing a small part of that problem, but they're certainly not the only way of addressing it, and certainly not a solution to the problem writ large on a national level. In essence, the Bridge program in South Carolina, which is not an acronym, it's named after the Ravenel Bridge that crosses the Cooper River, and it's meant to reflect the bridge to sobriety. But the Bridge program was our effort in South Carolina to be forward-thinking in our response to a perceived need for more sentencing options in the case of low-level, nonviolent drug offenders whose criminal conduct arises from their addiction. The nexus between the addiction and the offense that they're charged with must be established in order for them to be admitted into our program. So, as laid out in my written remarks, our key purposes were threefold: to provide the alternative tools to the district judges for this class of cases, to ensure public safety, and to achieve these first two goals with an eye towards fiscal responsibility. In developing the program, we observed as many federal and state drug court programs as we reasonably could, and we openly and unabashedly solicited advice and materials from those that were way more well-versed in the field than ourselves. We had a great opportunity to work with a state drug court judge in Greenville, South Carolina, Judge Chuck Simmons, who was the past chairman of the National Association of Drug Court Professionals, and he runs a program there in Greenville. He's run it for 20 years very successfully. We built the Bridge policies and procedures on the NADCP Adult Drug Court Best Practice Standards and the National Drug Court Institute 10 key components of the drug court. And we employ evidence-based practices embodied in those guiding documents. One common question that we've seen is whether these courts are really appropriate for the federal system. In our view and experience is that the social science underlying the drug court program is not specific to a particular court system, but it's really linked to human behavior and psychology generally. And the attributes of drug court programming are not system dependent, but rather human nature dependent. We've designed the Bridge program to maintain maximum flexibility with regard to the stage of the judicial proceedings that we can accommodate. Most of our participants are pretrial. It's primarily a front-end program, but we can accommodate post-trial participants and a hybrid of the two if necessary. But the key thing, and I've already mentioned it once, is the program is conceived out of and run through the authority vested in the judiciary by Section 3142 of Title 18. And Section 3142 shows that federal judges really are already regulating the defendant's lives in the ways contemplated by a drug court, but drug courts simply enforce the intensive treatment and supervision as provided by 3142 through regular judicial accountability. And that's key. And I think you've heard some other testimony here this morning where the role of the judge and the interaction with the judge on a regular basis just makes for a more powerful supervisory authority, and it works.
How many offenders are we talking about in a year go through this program?
Well, we've had 103 participants, and we're running it now in 4 divisions in South Carolina: Charleston, Columbia, Greenville, and Florence. We've got approximately
That's 100.
30 people in the program right now. So every year, probably in terms of graduation and completion, I would say more like 20
20 a year?
statewide, yeah, on a statewide basis.
On a statewide basis. And how does that contrast with the state, like the program you would see in Greenville, the state program?
In terms of the numbers that run through it, much fewer, probably half.
Half statewide versus what is in one area of the state in a state program.
Exactly.
Okay.
Yes, sir. Judge
Do you use
Breyer.
some sort of risk assessment in determining who's going to be put in this program?
Yes, and the U.S. Probation Office uses their assessment practices, and our eligibility criteria really is stringent and marries well with what probation is already doing in terms of we study the criminal history. We really drill down on the criminal history, and namely, they can't be violent or have any kind of a pattern of dangerous activity. But we don't just, if there's a criminal history that appears initially problematic, we don't just rest on that. We actually study it and look at the incident reports and so forth and drill down on it so that we can try to be as inclusive as possible with as many defendants and offenders as
Do you
possible.
have buy-in from the U.S. Attorney in this?
We do.
All the offenders are drug offenders?
No.
No.
Not necessarily. They can be fraud, counterfeiting. We've seen all manner, not necessarily drug offenders.
Are
But
they,
we do.
in fact, maybe less likely to be or drug offenders than, say, other offenses?
What's that now?
Are they, in fact, maybe then less likely to be drug offenders than, say, other kinds of offenders?
No, I think that the property offenders, there's really more property offenders than you realize in federal court. And the property offenders really tend to a number of them have addiction problems, and then the low-level drug offenders as well. But the key is to make sure that we can clinically diagnose and establish the nexus between the offense and the addiction.
Can I ask you a hypothetical? Let's say you have a low-level drug dealer who's an addict, heroin dealer, death results. Is the person eligible for the program?
Yes. I have such an offender in our program in
What do you
Charleston.
say to the families? of
Well, the
victims?
family actually endorsed, and the father of the victim came and endorsed the admission of this young college-aged woman who was using heroin with the person that died. They were using the same heroin, and heroin is, is so
What do you
dangerous.
say to the families that object to a person?
That did not happen on this one occasion. Hypothetically, I think that absolutely
Does the
would
victim's
take
family have a voice in whether
we'd
the
take that
person's-
into consideration. Of course, the victim would. In this one case that we've had, the victim actually was actually came to court and asked that the person be admitted.
Okay.
And she is very close to graduating now. She's a young college-age woman, and suffered some post-traumatic stress disorder as a result of the tragedy that occurred with the use of heroin. And as you all have probably heard by now, I don't know whether this heroin was laced with fentanyl, but there are some really dangerous misuses of opioids and heroin going on.
Can I just ask any of you at this point, but I know I'm previewers, do any of you have control groups where you're trying to match up people who would otherwise be eligible for your program but aren't in it to kind of track the, a real matched comparison group, someone in your program versus someone not, to see recidivism outcomes and other things? Or would you be
Scientifically
open-
random selected control group?
Like you'd have in an FDA double-blind study?
Well, I don't know if it has to be that, but
I mean, but that
researchers
idea.
that go
No,
in
no,
and study
but-
state drug courts and try to figure out. So I was thinking either a match population or some kind of study that you could say, because when you say it works, I guess I'm just trying to get a handle on works as compared to, this kind of goes back to the as compared to what question.
Go ahead.
We are in the middle of being evaluated by the Federal Judicial Center in a effort to determine a control group that we can compare our results to. So we don't have the results of that yet. We are expecting to hopefully conclude that study this year.
We did a study in 2009, and we didn't have, the reason I asked, I don't mean to be facetious, but it's a serious question about an FDA double-blind study. And NIH has done a lot of research about effectiveness of drug courts in addition to what the National Drug Court Institute says, and they've actually come to judicial conferences, and you could invite them. I'm sure they'd be happy to speak with you. But they advocate the drug court model because one of the things they say, that they basically say their research shows, at least my understanding of it, that their research shows that the criminal justice system is fairly poor at enforcing sobriety. It's fairly good at enforcing sobriety, but only in enforcing metrics, but it fails once you get out of prison because then people relapse. But the treatment is actually incredibly effective, according to, not incredibly effective, it's effective, and it's about as effective as with most other chronic long-term diseases, but the problem with drug treatment is people leave treatment. And what the criminal justice system can do is get people to stay in treatment. And so we did a study in 2009 of our and I think you need to be careful about the word reentry. It's a post-sentencing, it's a reentry court, but there are two kinds of reentry courts, reentry drug courts and non-reentry courts that don't deal with people with substance abuse problems, and there's a difference. And so ours, the one we did a study was our reentry drug court, and that study, and I didn't submit it to you because it's not about a front-end program, but I could send it to you, concluded in a general way that we did better than what the researcher did was we pulled data from people who were similarly situated on probation's caseload who weren't in the program and looked at those people and what happened to them in terms of did they accomplish the equivalent marker of graduation, the kinds of things that would be required to graduate in the drug court, or what did they do in terms of employment? And we did better on those kinds of things. I'm happy to send you a copy of the study. The problem with some of those studies is, of course, the numbers in any given program are relatively small, and so you need to look at metadata or larger things.
Judge Orkin, do you want to go ahead and start whatever prepared remarks? Or
Sure. I'm not going to repeat what I submitted in writing to all of you. I just have a couple different points that I want to make. I think, first of all, Judge Gee's suggestion, which I just heard for the first time here, about the amendment to the guidelines in terms of considering a probationary sentence if you've completed a program, this is a brilliant idea, both because it folds these kinds of programs within the guidelines, which I think do give a language to talk about in a framework. And it begins the conversation that you could imagine that guideline would begin, which is then what are the appropriate programs and what are standards and how to do, because we all know if you have children and your child broke their arm, you would bring them to the emergency room and expect the doctor to set the arm. And if it worked out badly, you wouldn't draw the conclusion that doctors don't know how to set broken arms. You draw the conclusion that that doctor, that hospital probably didn't do it right, or there was a more complicated problem. And so I think to some extent you have that's what Judge Faye Taxman was talking about in terms of quality programs. The fact that there's a program that doesn't work doesn't mean that the concepts don't work. It means maybe, but it might also mean maybe that it's just not being done well. So I endorse that idea. I think it's a great idea, and I'd urge you to consider it. With respect to Judge Reeves' question about diversion, I think that there's two other differences than we have what you describe in our district too. It's not too favored by our U.S. Attorney's Office, and it's mostly used for letter carriers who threw away the mail and had a drug problem or something, and they go to some level of supervision and probation. But our program on the front end, I think there's two differences. One is, in our program, you have to plead guilty. And then we don't make any promises to people, except the promise that it wouldn't matter if we made it, because I think we're legally required to honor it, which is to consider all the relevant facts at sentencing. So we make the you plead guilty, we'll consider the good and the bad at sentencing. Now, the
practical reality is if you do well, given how we're picking them, you're likely not to go to jail. We do have, with respect to, we have never had a death resulting case come into our front-end program. I think the answer to and we would certainly consider what the victim's family felt. But I think there's two answers to the question. One is the U.S. Attorney's Office is their formal voice. And in our program, we are operating essentially on a consensus basis, not as a legal matter, but as an operational matter, much as we have done for years with our drug court. And so if we haven't ever accepted anybody who the U.S. Attorney's Office objected to. So if they said, no, we want to prosecute the person for I think it's 20 years, right? 20-year mandatory, then we wouldn't take the right. But the other piece, and this is something I want to emphasize on our program, we haven't, and I think it speaks to just what you're asking about in part, we have a restorative justice component. If you want to be in our front-end program, which is a voluntary program, you have to participate in our restorative justice program, and there's 3 parts. First part is a short meeting with a restorative justice trained probation officer who just gives you an idea of what the restorative justice part is about. The second is a 2-day workshop that you have to, all day, 2 days, you have to participate in. So it'll be about 6 of the offenders. It'll be the probation officer or 2. It'll be some community services representatives. And we have a number of mothers whose sons have been killed in the drug trade who participate in this and sit in the 2-day conference with these people. And it's been an incredibly positive experience because one of our goals is we want the defendants to appreciate the harm that they caused on an emotional or human level, not in this abstract mathematical sense. And they do. And in fact, we just had someone who was a drug offender and convicted of drug distribution. He participated, and your question made me think of it because what he did, the third part of the restorative justice process is we don't require, but we encourage the defendants in our front-end program to do an individual restorative justice project where they make amends. So they've appreciated the harm that they caused, but now we want them to do something to make amends for what they've done. And because that's essentially, they've put the world out of order in some way by committing the crime. So what he did was he wanted to meet with the mother of a friend of his who had died of a drug overdose. He had never been charged in any way with the culpable responsibility for that, but he felt responsible for encouraging and participating in that young man's drug life and addiction. And so the mother was willing, and the two of them had a meeting where he, asked for her forgiveness. He confessed, in his view, his personal responsibility for her son's death. She afterwards, they came up with a plan of things for him to do, which he's now working on, to sort of try to take something positive out of what happened to her son's life. But she told separately afterwards, our probation office, that she was very pleased. It was both a hard experience for her, but she thought it was a very moving and worthwhile one. She was very happy to have had the opportunity to do it for herself, and that she thought it was a positive thing for him. So that isn't for every family, but it is an opportunity that if we don't provide it, that we are going to be denying it to some families. And so I think it's an important consideration. And this isn't in my written marks, but there are some similar restorative justice accountability programs that are on a voluntary basis offered in state prison in Massachusetts. And we've now, as a court, have approved a pilot to offer an 8-week introductory, voluntary, nothing. Like, it's just a thing that we're going to offer in the pretrial detention facility, because it's our belief from this experience that the Bureau of Prisons should be providing more opportunity for these kinds of programs. And that gets a couple quick other remarks. I see the yellow light hasn't yet gone on, that I want to make. One is, I suggest that the commission...
Sorry, could I just
yes.
interrupt you because I'm not following. You say the Bureau of Prisons, but these are your pretrial.
Yes.
Yes. This is all within the.
All within this. So we're not doing all the things I've described so far aren't with the Bureau of Prisons. They're all pretrial or post unsupervised release. But I do think the Bureau of Prisons should offer 2 kinds of programming. I think they should offer a kind of accountability restorative justice program, which has been pioneered, and it's offered in our state prisons, it's offered in the California state prisons. There's a similar program in the Texas Department of Corrections. It's run actually by a man whose wife was, his sister was murdered, and as an outgrowth of that, 25,000 people have gone through that program. And So I think they should offer that. But I think the commission, if I was looking at the organic statute, and the commission itself is charged with, in section 994, I think it's G, to make recommendations regarding the nature of prison facilities and services. And I think that that's one of the things that sentencing, as part of, I think, your writ. And I think that one of the things that happens at sentencing is we know more about the person than at any other time. And one thing that we have done in the District of Massachusetts is we now pre-qualify people for the RDAP program. So one could say we're just doing BOP's work, but it's actually a very sensible thing, because what's happened is now when a defense attorney says, well, I want my client to go into the RDAP program, we have hard information. Either they're appropriate or they're not. Our hit rate is something like 99% because our probation officers are trained by BOP. They like it. It does, so it gives us better information for that recommendation, but it does something else which is really significant. We have persuaded and worked with the Bureau of Prisons to create this pilot program. Now what happens, if you're in the District of Massachusetts, you have a drug addiction, you go to prison because that's what's the appropriate sentence, and if you do the RDAP program, when you come out, ordinarily, you'd go to the Residential Reentry Center. That's not a treatment facility. And the director, a lot of the people in the RDAP, who run the RDAP program, have told me they wouldn't send a RDAP graduate to a general population unit in a BOP facility because it would undermine the benefits of the therapeutic community that RDAP is. But the Residential Reentry Center is a general population facility because everybody comes out to it. So what BOP agreed to do is we're sending those RDAP graduates who are in this, recommended by the judge to be in this pilot, to a drug treatment program in the community that mirrors but it's a treatment program. Everybody is in recovery. They still go to work. They have the same responsibilities. Probation supervises them for the Bureau of Prisons, so imposes the same kind of restrictions.
So it's a specialized type of
Exactly.
Residential.
Exactly. And similar price, the daily cost. And so, but what it illustrates to you, I think, is that instead of the Bureau of Prisons being a silo over here, and the sentencing a silo over here, and supervised release a silo over there, we need to talk to each other and communicate and coordinate. And so we've created, it wasn't easy, and it took a long time, but we created this coordinated path. And I think there's a second group of offenders. This gets back to your question, Judge Pryor, with respect to our federal offenders different. There's a second group of offenders who are sort of the reentry court offenders who don't have a drug problem. And those offenders, truth be told, we see many of them, they're typically in drug and gun cases. They typically dropped out of school at an early age. They sometimes they smoke a lot of marijuana, but they don't otherwise have a drug problem. They've rarely worked at all. Sometimes they have a little bit of work history. And those people have a high rate of recidivism. They score high on the old RPI. They score high in various needs categories under PICRA. And what they need is a treatment program. They need accountability, responsibility. They need skills and work ethics. They need expectations. And one of the things judges impose in these programs is expectations. Casey Rogers, Judge Rogers, if those of you who know her, has a program in Pensacola that's focused with this population with cognitive behavioral therapy. This is maybe beyond my scope of the commission, but coming back to sort of encouraging programs under the organic statute, those offenders need sort of in-prison programming. They're not eligible for RDAP.
What are your numbers like? How many?
So they're relatively, we're talking about, I think our reentry drug court is up to 20. Our front-end program, we've had, in a moment, 46 people have applied since we began in August 2015. 19 became participants. We terminated 2, which means that they weren't, for one reason or another, working out. 6 have graduated, graduated, and been sentenced, and 11 are involved. So the numbers aren't large, but I think that goes to the second point, which is that there's not one type of federal offender. There's a range of people. There's low riskers, high riskers, drug addicts or not, and what we've identified is a group of people who we think we can do better with at and I would urge the court to think about it. One last suggestion, I know the red light is on, but I think it's an important one, which is I suggest you consider expanding the 5K departure, not touching and changing in any way the way it exists now with respect to government recommended departure for people who have substantially assisted in the prosecution of someone else. But I suggest to expand it to allow the government to file such a motion when the defendant, while he did not provide substantial assistance in the prosecution of someone else, provided substantial assistance in identifying and helping people who are in the community who are addicted to drugs seek and engage in treatment. And the reason I propose that now, in light of the opiate crisis, is because there are defendants who are drug offenders who have that information. So it's often in the Title III or other surveillance information the government's acquired. And those people are at great risk of harming the public and harming themselves, especially in a heroin kind of case. And they could die. And there are some incipient programs, at least in Massachusetts. There's a local police department that now couples their drug investigations with a piece to identify users and try to drive them into treatment. And recently I raised this once just at a sentencing, and the AUSA agreed to reach out and has a local detective reaching out to some of the people they identified. And I think that it's information that's available. It's sentencing significant, because if a defendant did that, it bears on his acceptance of responsibility in the way that if it's a drug dealer, he's making amends for what he did if he helps someone who he sold drugs to go into treatment. So I urge you to think about it. I don't think it tips any of the balance of authorities, because it would be vested in the hands of the government to make the motion or not. I know it's not provided for in the organic statute, but the organic statute doesn't say that's the only thing. It just says you should include or must include that. So
This is for treatment, not for prosecution.
I think, if they prosecuted the person, then I think they would fall within the first part, and you wouldn't necessarily need it. And I think that you could read it to encompass both prosecution in the sense of like a diversion or disposition in a state drug court that had a pre-adjudication, or just going to some sort of treatment program.
First of all, thank you all for being here and for sharing the experiences that you've had.
Speak up.
I want to focus on one thing that we heard from the first panel, and that's the importance of program quality and support. I've been going to criminal law committee meetings for many, many years, and my impression is that the general program quality and support embodied in our probation system and our probation officers is exceptional, especially compared to the state system. And so what I'm having trouble with really understanding is these are niche programs that you're describing that involve relatively few people compared to the docket that we have as a whole, which is 60, 70,000 people. What is it that makes these particular people, do you think, particularly amenable to some sort of special treatment as opposed to the standard program quality and support that we have through our probation officers?
I agree with you that generally the probation office does a very good job and has substantial resources, at least compared to what I see in the state system. I think one thing that these specialized programs offer that probation can offer that we haven't talked about this morning and they didn't talk about is sanctions. So at least when you have the ability, a judge can put somebody in prison on the spot, maybe just for a day. And I will tell you that when I started out and started our reentry drug court, I couldn't believe that any of the people we were seeing who had all served their prison sentences, many of them long prison sentences, that they would care about a day in the marshal's lockup or an overnight at the county detention center that we use. But let me tell you, they do. It is a very powerful sanction. And in some ways it may be more powerful, I'm not sure, but it might be more powerful with that category of defendants than someone who's never been to prison before. Because for them, it's a reminder of where they've been. And it is a powerful punishment. And it doesn't always work. I'm not going to sit here and tell you that every time we send someone in custody, boom, they took off like an airplane. But it was very effective. It's very powerful. And one of the things that happens when you're in courtroom is you can do that. It's like, no, it's early intervention. And the probation officers, and it depends on the district. In some districts, they might be able to. But the early intervention is not as swift. And there's a lot of research that shows you can change behavior by intervening as close in time. So that's one difference. So I'm not sure that's about the people, but that's about something you can do in the courtroom that a judge can do that the probation officer can't do. And that's very different.
I would agree with that. I think that studies show that if there's immediate response to behavior that is non-compliant, it is much more effective than waiting for whatever time it takes for a probation officer to petition the court to have that person brought in and face the court in the normal course. We meet with our participants weekly. And so on a weekly basis, we know what it is that they're doing and that we can respond immediately to any kinds of non-compliance. The other thing that I think is very important is that the people that we deal with form a bond with us. The team approach is very important because a lot of the people who participate have never had this type of structure before. And notwithstanding that the probation and pretrial services agencies do excellent work, they don't have the resources to do the kind of intensive supervision that we provide. And I think that is what makes the difference. And we have had 137 graduates from our program.
Over what period?
5 years.
5 years.
So we're averaging about 25 or so graduates per year.
Can I ask you about the composition of the population? I'm just curious, so I was looking at the percentages from each of the ethnic groups. Are these similar to the population overall in your district? So it was, so it's 10.66% are of Asian background, 28% white, 15% black, and 45% white Hispanic. Would that mirror the overall population in your district? Or
I don't think that mirrors the population of the county of Los Angeles, but it does in some respects reflect the prison population.
Can I come back to just one thing you asked? With one other aspect that I think these programs offer, that while the programs are niche programs and small, is a concept, and I don't know that I don't have a suggestion for you as to how to exactly incorporate it into the guidelines, but I think it's a significant concept, which is the concept of choice broken down to a point where the person who's before you can possibly make the good choice and build upon that. So one of the things that these programs do for the individuals is they break down, it's like I used to say to people, I don't decide whether you go to jail, you do. You choose. It's what you do that directs what happens. But it's on a small enough scale. It's not over the next 5 years, because if you look at the background of the person before you, they haven't been able to they haven't engaged in that kind of long-term planning and thinking, and they haven't developed those skills. So I think that giving people smaller choices so they can go down paths, good or bad, is a significant thing. And then they can, that doesn't mean to say that what happened before shouldn't count, it does. But wherever we build that into the system, I think is a significant thing. Where we have expectations for people, we give people hope, which is a very powerful motivator of behavior, and we have choices and consequences.
Right. I mean, we've been a believer in that for a long time. We have something called the drug intervention model, which actually started up in Boston, and it's about calling in people. This is even before the
right, in the
crime
80s.
has been committed.
Yes.
Right, but that's been spread in terms of anti-gang situation. But my question was all based on, is that scalable? Those call-ins involve dozens of people. It's very resource intensive. It is team-based. It involves the local preacher. It involves the prosecutor. It involves the law enforcement. But it's small.
I think it's scalable, but
it's the same thing
have
with
to
this.
think about it in a little bit of a different way. And I think that not every offender in the federal system needs to be in a program like this. But I think you have to think about what kind of problems you're trying to solve. I think if you're trying to work with drug problems, I think it is scalable, but not everybody in the federal system has a drug problem. And I think the first thing, I think all of our programs do this, is screen people with appropriate tools with respect to the drug problem. So you're identifying people with a serious drug problem, because the research shows that actually people with who have abused a little bit but don't have a drug problem, you don't want to put them in drug court. They'll do worse.
Our program is not a drug court. It is for potentially a large range of criminal offenders. But we have a large district.
Huge. Yours is the biggest, right?
Yes.
In the country.
Probably.
Right.
We have 4 different judges who preside over their own teams. And just like in public school, where class size is important to how much attention you can provide to the people in your class, I think the size is important as well, because we can't do a large program with hundreds of people at one time. On the other hand, when we have a group, and my group usually tends to be no greater than 20, we can then focus on individual needs and tailor our resources to the specific issues and problems that those people present. So in that sense, it's scalable, but you have to, in many ways, keep it relatively small so that you can do the kind of focused, intensive supervision that is so important to this program.
We've gone a little over, but we really appreciate your being here this morning and presenting.
Come visit. I echo what Judge Hendricks said. I think you would learn a lot from
Yes,
the
we have a new
actual.
courthouse. You're welcome to come and visit.
Well,
It's not as big as you are.
thank you for coming to
Thank
the
you.
district. Thank you.